You are watching Germantown Municipal Television, your source for everything Germantown.
Hello and welcome to Law Talk on Germantown Municipal Television. My name is Vince Perryman and I'm a local attorney with the law offices of J. Vince Perryman. Each month, Law Talk focuses on a wide range of legal issues and topics. On today's show, we'll discuss probate mediation. With us now is attorney Matthew Thornton. Matt, thanks for being with us.
Glad to be here.
So, this is, everybody thinks about probate, you know, that's going to be the dark court of death, I suppose, is one way to look at it since we're dealing with deceased individuals.
Yes, normally a bad time in a family's life.
Right. And it's one of those that when we put mediation in there, some people may be wondering, they're like, I thought this was just sort of winding up somebody's effects and distributing money. So somebody might think, well, with mediation, what problems are you solving? Is this with creditors or is this between family members? What's going on with that? So
typically, mediation is with family members disputing over, it can be disputing over things as small as personal property. Mm-hmm. It's amazing what people will spend fighting over something that is more sentimental than it is valuable, but they'll spend a lot of money fighting over it. So mediation is a way of kind of accelerating the process of arriving at a solution that everyone can live with. It can be a way of saving costs. It can be a way of short-circuiting a long and what would otherwise be a very expensive process. So it's increasingly favored by the judges as well as by the public.
Yeah, and I think that's always interesting because I know we've had some cases where we've had people arguing over stuff that would have been in the garage that looked like a garage sale, which I guess in one of those it was solved via a flood. But
yes.
So with this, I guess one of the questions that always comes to my mind with it is you have a lot of estate planners out there that are saying, hey, you should do a trust to avoid probate and avoid all these problems and these expenses of probate. Isn't mediation just going to be an additional expense of probate?
Well, it certainly is an expense because the mediator costs money. Normally your lawyers participate, and so the lawyers are charging as they're participating in the mediation as well. You know, for smaller end cases, you don't normally mediate because you're better off just fighting about it and getting it done. Meaning, you know, if it's a small amount of money or a small issue on personal property, to add the effect of mediation is potentially to increase the cost. But mediation is very effective for even, you know, mid-size and larger estates because if you don't mediate and reach a solution, then you're, you know, number one, you're putting your fate and the ultimate decision in someone else's hands, whereas that's one of the beauties of mediation, as you've probably discussed on this show. When you mediate, nobody's forcing you to do anything, but you're in control of whether you settle or not. And only if you and the other parties agree do you settle. But it's a way of maintaining control over the process. So when you're mediating, yes, it is an expense, but I would argue that if you can mediate a case and come to a resolution, even a partial resolution, you know, there's 5 issues out there, we can resolve 3 of them. That's still a success because it keeps you from having to pay your attorney and the other side from having to pay their attorney to fight about something, and it could take a lot longer than the mediation process would. So it's a good way to short-circuit the process. It is a cost, but it's a cost that pay me now or pay me a lot more later kind of an issue.
And I think that makes a good point because a lot of people think, well, it doesn't cost that much for me to have an attorney go in for a couple hours to court and argue this, and that's short-sighted because it's always the old adage with, well, I don't understand why an attorney costs so much, and it's all the prep work that we have to do before we go into the courtroom.
Right.
And that could be filing motions, responding to different materials, all sorts of things like that. Discovery, which can be really expensive.
Right.
I think it's you know, we've got some senior judges out there that have done some historical videos that they talk about how today we've got so much more money and time that goes into discovery that they view as really is it necessary to do all of that. And I guess, you know, if I had a divorce attorney sitting here, they'd say, yes, it's necessary to do all of that at a
Right.
rate of $500 to $600 an hour.
Right.
But like in probate, we normally tend to get along and everything. But it is one of those that with the, if it's something where somebody is involved in a probate case,
Right.
and they've got some issue that's come up to where there's a controversy and there's an opposing side to it, how would they go about getting their attorney to get to mediation?
Well, you can do it several ways. You can do it voluntarily, where your attorney calls their attorney and proposes the idea of mediation. That's one way. The other way is your attorney calls their attorney says, no, we're not interested. Then you can go to the judge and you can say, Judge, we really think this is a good case for mediation. We really think it would help the process along. The judge can then force the parties to go to mediation. Oftentimes the court will be deferential in that regard. If there's somebody who opposes it, either they don't have all their discovery complete, or there's still some facts to be developed, or some issues to be litigated first, the court will be deferential to that. But in our local rules in Shelby County, mediation is required in a will contest situation.
Okay.
And that's after the discovery is done. Then you sit down and you talk through it in a mediated settlement, mediated situation, to try to determine whether you can reach a settlement. So the court is not bashful about forcing the parties to go to mediation. It's certainly expected in some circumstances. And again, I'd recommend it if there's anything of value worth fighting over, and the parties really feel strongly about it, then mediation is often a good way to resolve it.
Yeah, and I sometimes I think too, just like making that offer where somebody realizes there's going to be this additional cost, that may get them to be more reasonable and be able to get it settled amongst the attorneys even before mediation.
It can. A lawyer's job is to try to give the best advice possible to the client, which sometimes means don't pay me to litigate this, pay a mediator and get it resolved. So I believe strongly in that. I think that our job is to say, this is your best way out of this. This is the solution that I would go with if I was sitting in your chair, even if it means less money overall in attorney's fees. And I think clients appreciate that fact. And mediation, if they see it, how it fits into the big picture, mediation can be part of that. There's a lot of satisfaction that can come from a mediated settlement that you wouldn't get if you litigated it, thought about it all the way to the end, and then you get a result you're not as happy with.
Well, and you also don't have the stress of waiting when the judge sits there and says, well, thank you all for your presentation today. The attorneys have done a great job. I'm going to take this under advisement, and then you got to wait 3 months or something before you get a written order that tells you what just happened.
Right.
And then even with that, you may be looking at, we've still got 30 days after that order comes out to wait to see if maybe this is going to be appealed by the other side.
Right.
And, there can be a bunch of other motions and things like that are going to be additional cost on top of it.
Right.
Whereas with mediation, you've got your settlement, you're good, and you can move forward with your life.
Right. We say in our firm that a bad settlement is better than a good lawsuit.
Okay.
And the idea there is if the terms are enough to where you'll take them, then we often recommend you take them, because you don't know going forward how it's going to turn out, the delays that are involved. It's inevitably always more expensive than you think it is. People all the time, and I'm sure you get this question, well, how much is this going to cost? I can't answer that question. I can't answer it definitively. I can tell you what I think and approximates, but we could get in there, and if they're aggressive, it could ramp up very quickly.
It's certain versus uncertain. So when we return, we'll continue our discussion about probate mediation. Please stay with us.
How long have we been married there?
For 76 years.
He was kind and generous to me before we married, and he was kind and generous to me all these years. We decided on Meals on Wheels because I was getting to the point where I couldn't do all the things that I had been able to do. We're the Spans. America, let's do lunch.
Drop off a hot meal and say hello. Volunteer by donating your lunch break at americaletsdolunch.org.
So we were walking to school.
I started thinking about lunch. Mom packed me turkey and cheese.
She's
I really want
smart.
cheese pizza.
Sometimes her mind wanders.
We should have a sleepover.
I remember saying, Laura?
I think I heard Mom say something.
The sign says don't walk.
Sometimes it's so overwhelming.
I really hope she doesn't
I
have
really
another
hope I
bad
don't
day
have
at
another
school
bad day at
today.
school today.
When you can see learning and attention issues from their side, you can be on their side. Go to understood.org, a free online resource with support and tools to help your child thrive.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. I'm Vince Perryman, and you're watching Law Talk. Joining us on our show is attorney Matthew Thornton. We are discussing probate mediation. Matt, in the first segment, we were talking about, the benefits of mediation and everything. And it's one of those that I think a lot of people are like, okay, well, I hear the benefits. How does the process of mediation work?
Well, the first thing is to decide on a mediator. The parties can do that voluntarily. If there's someone in the community that both attorneys and parties can agree on, then that can be the person that you select. The court is not really concerned. If y'all pick your own, that's fine. If you can't agree on a party or a mediator, then the court can appoint one. Often that is, as you said, from a panel of people that the judges are familiar with. It's often, retired judges who serve as mediators. I know Judge Brown and others have done a lot of mediations, particularly in the probate realm. And so once the mediator is selected, you basically retain them like you do a lawyer. You set it up for a date certain. They send out retainer agreements to each party. Normally the costs are divided equally between the parties. That can be mediated, meaning just because you agree to pay half and I agree to pay half on the front end doesn't mean that if we get to the end of it and part of the settlement discussion is if you'll cover all the mediation costs, then we'll resolve it and you agree to that, then we can mediate that point. So it's not set in stone. And that highlights, in essence, the benefit in my mind of mediation is it's fluid. It's what you agree to and what I agree to. And it could be that tangible things mean more to me than they do to you, and it could be that money means more to you than it does to me, and so we reach an agreement very organically that solves both of our priorities, and so that's good. So we select the mediator, we pick the date. Normally what the mediator does is they ask for statements from the parties. Tell me about your case, and they ask for that to be done confidential. At least I do. Most people I would expect do. Give me your strengths, but also give me your weaknesses. I won't share those with the other side. The other side I ask to do the same thing. Tell me your strengths, tell me your weaknesses. Kind of analyze your case so that I can see, number one, if I know that area of the law, which probate is my primary practice, I can see, do you have a good grasp on your case? Because that'll tell me how much I might need to either educate you or, push on you a little bit to say, yeah, but have you considered if this issue gets turned this way, or if this issue, if the judge were to decide it this way, that completely cuts against your case. In other words, that's an example. So the mediator takes some time before the date of mediation to review the statements, can review documents, what's been filed, can talk to the parties if necessary, although that's not normally done. And then on the date of mediation, everybody comes in, and there's different styles, different mediators do it different ways. There are some mediators who love to try to get everything done with everyone in the same room, with occasional breakout sessions, to try to let a person talk with their attorney over certain issues or whatever. There are others who have an initial caucus, a meeting, where they kind of lay out the ground rules, talk about what mediation is about, emphasize the benefits of resolving it today. We resolve it today. You walk away, you have a known solution to the problem, and you get to walk away. And then after that caucus where everybody's together and the rules are explained and the guidelines, if you will, then we have breakout sessions. So you and your attorney go to one room, and that party and that attorney goes to another room, and if there's more than two parties, everybody goes to a different room. And then the mediator kind of starts off with one and hops between the different groups, relaying offers, messages, relaying arguments that the other side is making, concessions that the other side wants, and so it's a very fluid and organic process, as I've used those words before, and that continues until some consensus is reached. And again, that consensus can be Well, or the parties quit. That consensus can be a partial resolution of all the issues that are out there. Usually mediators will push and push and push for people to resolve as much as they're willing to resolve. Not because it's a feather in the mediator's cap, but their job is to facilitate resolution. That's my job. So, to the degree I can get you to agree, I'm not necessarily saying, if I'm not your attorney, I'm not saying, yeah, that's a good deal, you ought to take it. And I'm not also counseling somebody else to say, ooh, you're giving up too much. That's not my job.
Right.
My job is to say, if you're happy with that number and they're happy with that number, then by all means agree on that number, if it's a financial. So the mediation can last a long time, as long as the parties are still willing to go. And oftentimes you do see later in the day, parties get tired and they begin to wear down and they're like, I'm just tired of dealing with this. And they realize how tired they are of dealing with the whole case. And they start beginning to make more concessions more rapidly. I had one recently where the parties came ready to concede some points. They knew that their case wasn't perfect on both sides. And we started at 9 and we were done by noon. And we had a typed agreement that we typed up right there in the office, commemorating what the agreement was. So that's probably been the fastest one I've ever done. But it's all, again, it's up to the parties. When you say you're ready to go, I'm probably going to push on that a little bit and say, we're really making some progress here. Let's see what we can do. And I usually do ask on the front end, when I get that retainer, I ask the parties to clear their entire day. And I clear my day. I'm not going to have anything else. I'll miss lunch. I'll miss dinner. We're going to stay until we get this done, as long as y'all are willing. So a mediator, is, again, designed to foster agreement, to encourage agreement. When I talk about earlier pushing on you, if I see a weakness in your case that you either have acknowledged or haven't, I'll push on you and say, you might want to consider, changing or coming down a little bit from your demand, because I think if I know the judges, I think that demand, you're shooting for the fence, and you may get that, but the chances you get that are much lower than the chances you end up somewhere down here. And so if you can settle it in this range, it's a good settlement. Same thing for the other side. I'll push on them as well. So my job is not to pick sides. My job is to facilitate agreement to whatever degree I can do that.
And the one important thing that I tell everybody going into mediation, just in general, make sure as you get to agreements during the day, it gets typed up so it can be signed before everybody leaves, because we see that so many times.
Yes.
Where people come out and they change their mind and you thought you had an agreement. And that's one where I've found that is one of the most important things to remember on that.
Yes.
So when we return from our break, we'll talk more with Matthew about probate mediation.
Well, Thomas, you've got prediabetes. But with more exercise and a change in diet, it can be reversed.
I've tried exercising. It just makes me hungry for bacon.
I love bacon, too. And who really likes to exercise?
Not me.
Me neither.
Nobody. So we're good?
What? Oh, you still have prediabetes. Big time.
I'll be right back. Hi. You think you're probably sober?
Yeah.
But you're thinking about taking the back roads home, just in case. If you're probably sober, then why would you do that? Good choice.
Probably okay isn't okay. If you see a warning sign, stop and call a cab, a car, or a friend.
That's a full glass of wine. I'll be chatting you later.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. With us now is attorney Matthew Thornton. We're talking about probate mediation. Matt, before the break, we were talking about benefits and the process of how mediation works. And the one question that comes to my mind are, what are the credentials? Is it like a license, like we have law licenses, or what makes somebody a mediator?
Well, there's no formal there's no formal requirement for anybody to mediate a dispute. By that I mean, if you're a parent of more than one child, you're a mediator because you're going to have to mediate between the two of them. So anytime there's conflict, you can have a person who's a mediator, formally or informally. There are actually people who are non-lawyers who are mediators. You don't have to be a lawyer to be a mediator, but there are some people who are just very good at bringing people to a resolution. They just have a personality style and a type that is conducive to encouraging people to resolve matters. And so I would encourage anybody who has that natural ability to then take the next step, which is to become licensed. And you'll hear that listed. I'm sorry, forgive me. Rule 31 listed. Rule 31 is a rule of the Tennessee Supreme Court. And so you go through 40 hours of training at a minimum for civil mediation. And then for family mediation, there's an extra 8 to 10 more, probably more hours. And I didn't go there, so that's why I don't know. But you get extra qualified on family mediation for divorces, custody issues, and things like that. The benefit of being Rule 31 listed is that you are eligible to be a part of a formal mediation process. There are rules associated within Rule 31. There are requirements and also procedures that you follow. There's protections associated with being Rule 31 that may not be present in other mediated settlements. And so I definitely encourage people to consider that. If you're a lawyer, and you can say you're also Rule 31 listed, to me that's an extra bonus, an extra feather in your cap. Plus, if you do like I did, this is for the lawyers out there, you stop taking CLE for a year, and then you build up to where you need 30 hours of credit for this year and 15 for next year, and then you take your 40-hour class and it counts towards your CLE credit. So it's a way, particularly when you pay your own CLE, continuing legal education, it's a way to do that. Word of mouth is a good way to pick a mediator. By word of mouth, I mean you know somebody who's been through mediation and they thought their guy or gal did a good job. You definitely hear different stories. People have different impressions of different people, and some people just don't resonate with others. And so just because you hear one person maybe had a negative experience with a mediator doesn't necessarily mean that mediator's not a good mediator. It just means that particular session wasn't productive for them. But a lot of the mediators in town are lawyers. That doesn't mean you have to be, but they understand the legal issues. They are good at bringing people to a resolution. As far as cost goes, as far as what the cost of a mediator, I've seen really good mediators who are relatively cheap, and I've seen other mediators who are what I would consider average mediators who are very expensive. So there's really just because somebody's expensive doesn't mean they're good. Same way with lawyers, I guess. And just because somebody is good doesn't mean they'll be expensive. So it's really more of a kind of just seat of your pants decision to me. If it feels right, if your lawyer thinks they're good, and other people that have had decent experience with them, then I certainly pick them. But it's not like you go through multiple mediators, so you don't ever really get to compare, well, this guy did a really good job in the mediation, and then this gal didn't. So
unless you're in 7 years of custody litigation.
Yes, 7 years of custody litigation, I can see how that might work out to where you have multiple experiences with mediators and different judges, and you could evaluate the whole process.
This is true. Not that I would know anything about that, but so when we're talking about probate mediation, a lot of times these are, this is somebody else's money that's being argued about that hasn't been distributed. How old does that work?
Well, typically the person who's in charge of the estate, let's use an estate as an example. Although I've seen even conservatorships where you're vying for control of a loved one, you can even mediate there. But let's say there's an estate situation, and mom or dad has passed away, leaving $100,000. Well, the executor is not going to distribute anything until the disputes are all resolved. They would be foolish to distribute all the money. So you've got this pot of money sitting there, and with the mediator's blessing, that can be billed against that estate money. So it's not having to come out of anybody's pocket. There's pluses to that because, to me, that's one advantage of the probate practice in general and mediation is it's not as painful when you're just giving up a slice of what you were otherwise going to get versus you're writing that, fat check. That's very difficult to do, and there's a lot of emotional pain. That also cuts both ways in the sense of when you are writing checks from your own account, you're more motivated to settle than you would be when you're just somewhat depleting a pot that's out there that you're still going to get something out of. So there's that dynamic when you talk about probate mediation that's not normally present in business disputes, and other types of disputes that are legal disputes that you would mediate a resolution to. There's also mediation that's not in the legal realm, and that is I've seen victim mediation, perpetrator-victim mediation, where Christ Methodist has a program where young men who have harmed a family, stealing from them or whatever, in essence come to this mediation for the purpose of the family getting to express real world emotions. That hurt, I felt violated, etc. The young man gets to hear that, and restoration is the goal.
Okay, yeah, that's very interesting. Unfortunately, our time is up for this edition of Law Talk. I'd like to thank our guest for taking time out of his busy schedule and for being with us and sharing his thoughts and insights. If you'd like more information about Law Talk or any other program on Germantown Municipal Television, please refer to our website at www.gmtvonline.org. Thank you for joining us today, and be sure to join us next month for more legal topics. Until then, I am Vince Perryman, and thank you for watching.